Hello there! As we will cover the discussion on the construction and interpretation of words and phrases, series of case presentation will be presented. We'll start on the language of the statute. When the law does not distinguish, courts should not distinguish. What does the language of the statute means? The rule, founded on logic, is a corollary of the principle that general words and phrases of a statute should ordinarily be accorded their natural and general significance. Here is the order of the case presentations. Case number 1, AFPFC versus Yahon by Ryan Cloyd Villanueva. Case number 2, Pilar versus COMELEC by Ray Angelique Byron. And case number 3, People versus Evangelista by Edgar Riquelme. Hi, good day. Here is the first illustrative case. Armed Forces of the Philippines Finance Center versus Daisy R. Yahon, GR number 201043, dated June 16, 2014. Facts of the case. Daisy Yahon filed a petition for the issuance of protection order under the provisions of the Anti-Violence Against Women and Their Children Act of 2004 against her husband, who is an enlisted personnel of the Philippine Army who retired in January 2006.
This can't be. I need support and protection. I need to file for a petition for protection order and for financial support.
Hearing the petition of Daisy, in the year 2006, the Regional Trial Court issued a temporary protection order. The following year, another court order was issued.
Mr. Yahon, here is an order of permanent protection which directs you need to give 4,000 pesos per month by way of spousal support.
Pursuant to an order issued dated February 6, 2007, Senior Sergeant Yahon was directed to give the 50% whatever retirement benefits and other claims he may receive, which will be automatically deducted from his benefits and claims to be given directly to Daisy.
We shall file before the RTC a manifestation and motion to lift the temporary protection order against the AFP. The RTC had not acquired jurisdiction over our institution due to lack of summons. AFPFC cannot be bound by the said court order. We will be filing petition for certiorari to the Court of Appeals, praying for the nullification of orders, especially on the auto-deduction from the benefits and claims of Senior Sergeant Yahon. The order of allocation was illegal, since the money remains a public funds.
The issue of the case: whether or not the benefits of a government employee can be a proper subject of garnishment pursuant to Republic Act 9262. Section 8 of RA 9262 used the general term employer, which includes in its coverage the military institution, Senior Sergeant Yahon. Where the law does not distinguish, courts should not distinguish. Thus, the provision applies to all employees, whether private or public. The law is clearly intended to create limited waiver of sovereign immunity so state courts could issue valid orders directed against government agencies attaching funds in their possession.
Hello everyone, here's another illustrative case entitled Juanito Pilar versus COMELEC, GR number 115245, July 11, 1995.
Yes! I did it! I have submitted my application.
23 days later, he withdrew his certificate of candidacy.
Never mind. Maybe I'll just run in the next few years.
Excuse me, Mr. Pilar. You need to pay 10,000 pesos due to failure to file your statement of contributions.
What?
In 1994, COMELEC denied his petition for the motion for reconsideration.
I'll file another petition to the COMELEC and bank.
It is stated in Section 14 of the Republic Act No. 7166 that every candidate and treasurer of the political party shall within 30 days file in duplicate, true and itemized statement of all contributions and expenditures in connection with the election. Offenders shall be liable to pay an administrative fine ranging from 1,000 pesos to 30,000 pesos in the discretion of the Commission.
I am a non-candidate. I have withdrawn my certificate of candidacy 3 days after its filing. This is absurd.
The issue: whether or not the petitioner can be considered a candidate despite the withdrawal of his certificate of candidacy. According to the court, the petitioner's argument is without merit. To reiterate, every candidate is obligated to file for his statement. The law makes no distinction. Every candidate must be deemed to refer not only to a candidate who pursued his campaign, but also to the one who withdrew. It is a well-recognized rule that where the law does not distinguish, courts should not distinguish. As a general rule, the use of word shall in a statute implies that it is mandatory. Wherefore, the petition is dismissed.
Another illustrative example of the doctrine, if the law makes no distinction, neither should the court, is a case of People of the Philippines versus Judge Antonio Evangelista. GR number 110898, February 20, 1996. Here in this case, Private Respondent Gildo S. Tugunon was charged and convicted of frustrated homicide.
Appreciating the privileged mitigating circumstance of incomplete self-defense and the mitigating circumstance of voluntary surrender, this honorable court hereby convicts you, Mr. Gildo Estugonon, with frustrated homicide.
No! I will assail the decision of this trial court.
Meanwhile, on appeal, the appellate court affirmed the decision of the respondent's conviction. However, modified the sentence by imposing an indeterminate sentence of 2 months of arresto mayor as minimum to 2 years and 4 months prison correctional as maximum. The RTC then set the case for promulgation. Then, Tugunon subsequently applied for probation. And the Chief Probation and Parole's recommendation was,
I will recommend a denial of Tugonon's application for probation. His right to make an application for probation is deemed waived after he appealed the sentence of the trial court when he could have then applied the same.
Despite the Probation and Parole's recommendation, the RTC however granted Tugonon's application for probation. Hence, this petition by the prosecution. The issue of the case is whether or not the RTC committed a grave abuse of discretion by granting Tugonon's application for probation, despite the fact that he had appealed from the judgment of his conviction of the trial court. The Supreme Court held that there is indeed a grave abuse of discretion.
The probation law was amended by PD number 1990 stating, no application for probation shall be entertained or granted if the defendant has perfected the appeal from the judgment of conviction. The filing of the application shall be deemed a waiver of the right to appeal. With regard to respondent's argument, a distinction should be drawn between meritorious and unmeritorious appeals. The court ruled the law does not make any distinction, and so neither should the court. If an appeal is truly meritorious, the accused would be set free and not only given probation.